please don't let me do it. Don't put me in residential. Don't. And I listen. We put you on probation. A month and a half later, you pick up a felony DWI. So all this, you know, acting.
I heard that.
Okay, Dustin.
So, one issue, as far as the GPS monitor and all that, they gave him a new device just now. They said it was a charging issue. They put it in, it would charge for him to stop charging. He has a brand new one they just put on this morning. Now, the drug test
violation that he's out at 3 a.m.
Well, no, it's not that he's out, is that that's why he reconnected. So but they gave him a brand new device. So if they're saying there was an issue where they changed the device out and there's not a tamper on it, it's just, it said it was not receiving. They didn't say it was that he was out and about, it said it wasn't receiving, and they started receiving again. That's at least the report that I saw. It's not like they were tracking him other places. But as far as resolution of the case, I did talk to him and he is interested in participating in DWI court. And we talked about that last week. I had a visit with him on that this morning.
This here on 3/11/24, GPS device generated a failed to enter alert at 10:15 p.m. At 11:46 through 3:02, GPS device was in no GPS no cell status and was unable to be monitored during that time frame. Client arrived home at 3:01 a.m. on 3/12.
So that's not when it arrived home. That's when it started charging again. Because it's not the geolocate. I mean, as far as I'm understanding, it's the GPS shows where he is.
I'm
Not.
going to be honest, Your Honor, that would be a question for pre.
Oh no, I'm sorry. It's pointed to the client, not to you.
Okay, I was like,
Saying he's out and that he's out in the middle of the night.
I don't think they're saying that. What they're saying is it's received a no signal.
Client arrived home at 3:01 a.m. on 3/12.
What received before that?
Huh?
They don't know where he was before that. He was at home. He just wasn't charging.
You have.
That's the way I'm reading it.
Do you have? Do you have the idea of where he is?
I don't see any notes from the case manager, and then at 10:05, I see on the report, it's showing that he's not at his home location. So I think that would be the fail to enter. And then there was the portable violations as well that were added. But again, from what we discussed earlier, I don't, necessarily have to go for.
Portable to violation in what respect?
They sent an email yesterday from the supervisor that was here earlier stating that there were additional.
Did Anthony send that?
No, it would be from Cody Pittman.
Okay, see.
This specific one is from Luis Galvan.
So I also have here, client was also instructed to obtain a portable alcohol testing device, comply with all testing protocols, refrain from alcohol consumption, and comply with all routine equipment service. The defendant failed to provide breath samples, scheduled times, resulting in 13 skips from 2/7/25 to 3/17 of 25. So he's still skipping tests. Come up, Mr. Jones. I just don't get it. I truly don't. It's over and over and over. You are still skipping tests. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping tests. I mean, I have no other choice. I now have to revoke your bond again.
Let's do a plea then.
Huh?
Let's plea it.
I agree with, and I'm okay, but I'm going to tell you now that I want to have him TRAS'd immediately to see how we go forward.
Well, Judge,
You know,
okay.
just all I want you to do is not kill anyone, man. That's all I want. Really, I'm not asking for much. You have since day one in our court have repeatedly refused to comply with bond conditions over and over and over. And I'm not doing a plea to where he can just get out and just do, and
So
you scare me.
So how do we resolve, Judge?
Huh?
So how do we resolve it?
So, yeah, I agree with you. I think that the correct thing to do would be probation.
Okay.
But I would like to have him TRAS'd while he's in there. And I have a feeling I know what the TRAS is going to say. And that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
It's just costing me money, Judge. Already costing is his family money.
So it's okay to just skip tests?
No, it's not. It's a test, but I'm saying
It's
is
escape. I'm not just be asleep, and I'm not trying to escape. Your Honor, I swear to
just
God.
stop talking. You don't
Sure.
just stop.
Okay, he goes, It's literally, so bad, because the minute he gets out, we have bond violations over and over and over. Now, what are we now, Jay, what?
If the court wanted to be made aware of the presumptive results.
What do you test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
You tested positive for Oxycontin?
Yes, Judge, presumptively positive is being sent to the lab for the testing.
What I had envisioned, what I think is probably do like a 2-year probation. I want to do like maybe 10 days as a condition, do an immediate TRS. We'll get it done today, tomorrow, and we'll see what the TRS says. And I'm going to go with what the TRS says. If the TRS says, and I promise you, Dustin, I will do what if the TRS says that IOP, SOP is the proper course, then I'll do it.
Okay.
You know, but if they say residential, I think that's, I want to follow what the TRS says because I think that's the proper one.
I don't think you can take it.
Hmm?
I just don't think you can take it if it's residential.
Then I have a jury waiting right now.
You should say, I mean, let's just see what it says. Let's try to get a quick.
For sure.
So,
So do you want to do the probation?
yeah, he wants some probation.
Okay, let's do it. Okay, Blaze, you let me know.
On this
Jim's probation.
Okay, yeah, I mean, we had offered the probation on the first, so, yeah, it's TRS.
So,
Okay.
so probation with
2 year.
TRS conditions.
2-year.
Okay.
I want to do 10 days as a condition. That way I can get the TRAS done now immediately while he's in. And then I'm going to follow whatever the TRAS says. Are you Dad?
Yes.
How are you?
Fine.
Thank you so much for coming.
Can I say something?
First, go with Dustin first, because I don't want you to say something that really, just please. Yeah, you guys can talk and then later on, if it's, then, thanks, Dustin. All right, come on up.
All right, so what we're gonna do, Judge, is he's not gonna want out. We're gonna reset it for she said she'd give it a TRS in a couple days. I got him, he wants to see what the TRS is gonna say if he recommends DWI court, because that's kind of what he wants to do. Pretty much I think he'd be more successful in DWI court. So let's get the TRS done.
In sober court, he just wants to be out, so he doesn't have to be in custody, but the problem
This
is,
is gonna be in your court.
it won't be in my court.
I understand that.
So-
But he's not wanting out, Dad's not wanting him out. I told him he needs to sit and have TRS done, and they can get it done. So I'm gonna reset us. What, 5 days, Tuesday, and let TRS by then. He's not gonna want out, because Dad's, we're not wanting out.
You want to talk?
Yeah, I don't want him on. That's the judge.
I get it. I understand. I understand. I understand.
So, we'll do five reset for Tuesday next week, then they have to rest on by then.
Okay. All right.
Thank you, Judge.
Yeah. So we're not doing a plea today, but hold on. Dustin, come on up. I want you to know that if it says residential treatment
Understand.
and he's no, I mean, I'm setting this case for trial, right? And I'm not gonna,
Are all straight probation?
I understand.
Okay, cool, I heard for.
No, he was asking.
No.
It's not legally possible.
my concern is that what I feel is gonna happen is when he does a TRAS, they're gonna say residential, and he's gonna say, I don't want to do residential, I want to be out. When we know, based on here, it just doesn't work when he's out. He does what he wants to do.
If he
To
doesn't,
hell with the
if
conditions.
he doesn't want the TRS recommends, then he'll take a jail sentence, and that's just what it is.
I'm not gonna take that. No, I'm not taking it. I'll send him for trial. I'm not taking, no, because this,
We'll plead to a jury and do jury punishment, and he'll get a jail sentence. Like,
you can do what you want,
he's not
but
probation eligible for a jury. You can't force him that probation. I would say the TRS.
no, I think I can. I mean, I think I can. I mean, I'll look the code, but
If I do jury punishment, you can't. Like, you see what I'm saying? It's like, I do jury
I mean,
punishment,
sure.
you can't.
Sure.
But I'm not trying to. Let's just get the TRS and see if we can get it. They help if you want to. Yeah.
Dustin,
I know what, dude, we're on the same-
giving him a jail sentence of 20 days, 30 days, 60 days solves nothing. It literally throws him out into the wolves and he's just going to pick up a felony DPI within the next 30 days, 60
Let's see
days.
what the TRS says and see what we can do.
I'm trying to help this kid, man.
I know you are.
And just a straight jail sentence it's within a year, he'll have a felony DPI.
I understand. And you know I understand. You know we're on the
All right, so let's see what the TRS says and yeah, let's pointless an argument. I agree. Let's just see what the TRS says.
Is it? Thank you.
Question. The defendant violated probation by skipping 13 breath tests, testing positive for THC/suboxone/oxycodone, and having GPS monitoring gaps between 11:46 p.m. to 3:01 a.m. under Texas CCP Article 42.751, bond revocation, and the Fourth Amendment's protections against unreasonable search. Was the GPS monitoring gap sufficient legal grounds to allege a bond violation, or does the defense argument that it was a device charging issue raise a valid due process challenge under the 14th Amendment?
All right, good morning, Mr. Reynolds. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 10th, 2025, officers were patrolling the area of the 13,500th block of Beechnut Street, Harris County, Texas. And they observed a white Hyundai Kona with an aluminum pole stuck to its hood due to a recent crash. A traffic stop. A aluminum pole stuck to its hood.
An aluminum pole stuck to the hood of a car.
Yes, Judge.
That's the stuff.
Yes.
Okay.
This is word for word what when I observed a white Hyundai Kona with aluminum pole stuck to its hood, comma, recent crash. I then got behind the vehicle and yeah.
Yeah, keep going, please.
Okay. I went back and got behind the vehicle. The officer started speaking with the defendant, who admitted to being driving and that he had crashed. The defendant told me that someone swerved into his lane and crashed into a pole. The defendant stated that he already called his record and that he was good to go. The defendant did not show any intentions of going back to the original scene and gave his information. While the officer was talking with the defendant, a security officer told the client that some people flagged him down the street, saying that the defendant crashed into multiple parked vehicles and drove off. The officer detained the defendant and went back to the original scene, which was a quarter mile from where the officer found the defendant.
Now that adds to it. I mean, that's certainly.
The officer spoke with a witness who stated that he was by the front of the apartment when he saw the white vehicle losing control, crash into a pole, and kept on driving while hitting another two vehicles. The witness stated that he was going around 60 to 70 miles per hour in a 35 mile per hour speed limit zone. This confirmed how the aluminum light pole got stuck to his hood. The witness stated that he did not see anybody else around the vehicle before the incident. The officer spoke with one of the owners of the vehicles that was struck, and she stated that it will be around $200 to fix her vehicle and wants to pursue charges. The complainant of the other pickup vehicle had damages to the back right part of that vehicle, and the complainant stated that the defendant crashed into her vehicle and left without providing information. The defendant left the scene without, okay. At this point, they called intake, and then they completed an inventory search of the defendant's vehicle and located a black backpack with 7.4 grams of marijuana, multiple clear plastic bags, and scale.
Is he under arrest? I mean, if he's under
So
arrest,
they
then,
called,
but I didn't hear that he's under arrest or anything. They just up and go start searching?
they did say that the officer called DA intake and spoke with an EDA who accepted charges of the FSGI. And then it states there was an inventory search conducted.
Okay, so they did arrest him but what happened? Because is there an FSGI charge?
We're going to be honest, Your Honor, I'm not entirely sure what happened there. I'm working on it right now. If there's FSGI, right now I'm working on the complainants. We'll get things worked out that way.
I mean, I don't
Right now, we do
understand.
not have an FGI charge at this very second.
Did they accept it or did they not accept?
Based on the DIM statement, it says that we accept the charges. So I am trying to see why there is not a charge, but it's not something that I know.
What a weird day so far.
Your Honor,
Can I say something?
No, don't. Now's not the time. I'm gonna give you a lawyer and you can tell your side to the lawyer, but,
I think there's a quick glitch in our internet system, so they find marijuana, but They just, wherever, yeah, the change.
Is it going to go through? Do you know?
I need to look into our system, or to figure out why it didn't, if worse comes to worse, we can be entry. But
So I'll give you, I guess, let's do this. I'm going to appoint a lawyer today and I'm going to find probable cause for the moment, but I want to revisit it within the next couple of days to see what is going on. And then, all right, so I am going to find probable cause for now, Mr. Reynolds. Can you look to see if he has a license, please?
Yes,
Driver's
Judge.
license. How old are you, Mr. Reynolds?
I'm 26, sir.
His driver's license is not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life. I don't care if you need groceries. I don't care if you need this, that. If you don't have a license and liability insurance, you're not allowed to drive. I will give you a lawyer today. You can say you're signed to the lawyer, but if you don't have a license and car insurance, you're not allowed to drive. Do you understand?
Yes, sir.
That is a condition of your bond. If I find that you do, I will revoke your bond, put you in jail, and no more PR bonds for you. So what I can have you do is I'm going to have Deputy Miranda give you an application. I'm going to have you fill it out. I'll have you talk to a lawyer today. But I guess let's do that. I'll have you talk to the lawyer and then we can revisit the situation after you talk to the lawyer. Please.
Thank you, sir.
Hi, Bud.
Approaching on Reynolds, I think, reapproaching on PC, I believe. He's over here on a possession of marijuana. She said you wanted to reapproach, so that's.
Well,
It seems awfully fishy. I'm not sure why they detained him for FSGI. I do not understand that.
well, I think that there's a valid claim for an FSGI because someone says that there's a guy barreling through a neighborhood, hits a bunch of cars, takes off. We have someone that puts him there, right? That
Yes.
says it's him. My concern is that they say they accept charges for FSGI, right? But we only have a POM.
I understand.
I don't get it.
I
Just-
understand. That makes no sense to me either.
So what I did was I found probable cause for now. I'm going to give them another couple days to figure out what happened. Why was it a glitch in the system?
Just for what it's worth, according to my client, he was on scene. He wasn't away from the scene. He was by his car when they were arrested him.
See us?
way away from the accident.
Well, the accident happened and the car went forward and hit something. Anyway, it's okay. But
Show me.
either he's FSGI and they can prove that he belonged to that marijuana, or they can't prove that he
So
belonged to that
let's do
marijuana.
this.
That's fair.
Why don't we set it for a formal probable cause?
That's fair.
Days. You pick it. I don't care.
Next week, okay?
Sure.
Okay, sure.
And then that gives them enough time to also look into why,
Gotcha.
what happened with the FSG, why is it not, you know?
That sounds fair.
In the interim though, come up.
Mr. Reynolds?
You tell me he doesn't have a license, right?
It is not eligible, Your Honor.
Like I have here that he's trying Uber or something like this.
That's correct. That's my
I can't
understanding.
drive. You don't have a Texas driver license, right? No. It's a yes.
You have a valid Texas driver's license. is what-
Yes, as far as I was aware.
They're looking into the Texas.
I understand what
system
that just
because
said,
It's
sir.
not valid.
Right.
So you don't have a license.
I understand that now, sir.
You can't drive.
I understand that,
Don't
sir.
drive.
Yes, sir.
If I find that you drive, I'm gonna lose it.
I
I'm telling you
understand
now,
that, sir.
I will put you in. Because all I'm asking you to do is follow the law. I'm not asking much. If I find that you're driving, and I don't care what your excuse is, I don't care if it's a burning building and you have to say 50 kittens, I'm gonna lose it. You will be signing a promise with me. This is an affidavit that you're gonna promise me that you're not gonna drive. Do you understand? It can go really sideways if you do. All you need to do is contact DPS to figure out what you need to do to get your license back. I'll even give you the phone number. Let me see.
I already have that information, just like,
Oh, there it is. Wow, we
Yellow, you want blue? He's gonna give it to you. Just let me give it to you. Call me this afternoon and we'll figure out why it's not valid.
So this is the number to the driver's license division, the DPS. When you call them, call at 7 a.m. Don't call at 9, at 2, at 1:53. You'll never get through. You have to call when the phone lines open up, give them the number and ask them why it's no good. And they'll tell you.
I need the SR22.
Oh, well, there you go.
I had
Then you know why.
Oh,
almost, I was just working Uber every day, so I didn't know.
But he said you can't do that. Don't worry. You don't need to say anything else. He's got it figured out.
look, Mr. Reynolds, do not drive. Do you understand?
Sort it
Yes,
out.
sir.
And you need car insurance before you drive too.
Oh,
We'll fit.
Okay.
We're gonna be back next week, so we can answer all just next week. We'll be back next week. I'll answer. All right.
gotcha.
Hopefully you get that sorted out. Come back, that thing says eligible. You'll be good to go. All right. They don't lift that restriction, I think is what he's saying.
Okay, come on up, Mr. Reynolds. We'll have you sign this and then you'll be free to go. Good morning, Mr. Ibarra.
Good morning, sir.
So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, this is a under 21 UCW. I can still read you the facts if you would like. Okay. On March 3rd, 2025, an officer was dispatched to a shooting. The officer found the defendant in a back alleyway with a gunshot wound to his leg. The defendant had a mesh backpack in his possession at the time and was able to see that there was a black handgun inside. The caliber of the handgun matched shell casings located on the ground next to the defendant. The defendant stated that he shot the gun in self-defense at 3 black males who shot at him. Those suspects fled the scene after officers' arrival. The defendant was transported to Ben Taub Hospital where the defendant was being treated for the gunshot wound to his left femur. The defendant admitted to being in the 114th Street Bounty Hunters gang and is 18 years old.
Okay, so was it really that, did he shoot himself or do we know that someone else shot?
We do not know. We
So-
know that the casings on scene match the caliber of the handgun that he had, but we don't know if he had shot himself and he stated he was being shot at by other people as well. So it's unclear.
So the only allegation is that he's underage, essentially. Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward in your case. You need to be very careful. You get but one life. You know, God forbid something happens where you have a gun and you use it and then you end up getting charged with something. You've gotten shot in the leg now. I mean, luckily it's not somewhere else. It could be life ending.
Sir.
When you hang with dogs or when you're bad places in the middle of the night, really do something with your life. Get into school, graduate, get some knowledge.
Sir.
Take a seat.
I have Ms. Salmaron on the docket, Celia Salmaron.
How's she doing?
She did a T-RAS. It looks like they're recommending like the women's residential. Yeah.
Yeah, that's a good idea.
So the issue, Judge, she needs to be on a probation. She has 2 open PCSs currently.
No rush, really. That's probably the appropriate thing.
Okay, so her felony court date is March 28th. And the problem is that I just, so she has the old PCS, but she has a new one. And, you know, she's not going to be able to bond out. The felony court did give her bonds, but she's not going to be able to afford those.
And asking for
A trial date. My problem is, Judge, it could take months and months for them to get the lab back on the PCS. Or I can get a
Do they have
reset.
the last bag? I mean, how long?
I'm sorry, I didn't catch.
So-
Salmaron.
Okay,
You were paying attention.
okay.
Yeah, it's an old case, Mom. You're right. I didn't realize it's from May of last year.
It does appear that the labs are still pending.
Yeah, is it really going to take that long to get? I mean, how long do you think it'll take? Do we have any, are the labs back on the first case?
Yes, Judge, I think they are, because I think they're in connection with this DWI.
Have you evaled it? Are you ready?
I'm ready. I mean, I was ready before she forfeited, so.
The labs are back on the second case.
It's the same case as our case. Yeah, I have no idea how long it takes to get labs back. You don't know? Seriously?
We have an offer in there. It's an old case. We can set it for trial today if that's what you want to do, Judge.
It's not me, it's Connor. I'll do whatever you want. It doesn't matter to me. If you want to set it, I'm fine. If you want a little bit more time, I'm fine with that too.
Yeah,
You tell me, you're in the driver's seat.
I think that, so she has court next Friday. If we could get just a couple week reset, see what happens next Friday, see if they get the labs, and then if not, then we can.
And, you know, perhaps have her see how long it'll take.
Yeah, I'm gonna
Ask
reach,
someone else.
I'm gonna reach out to her felony attorney and then maybe the prosecutor, see if we can't work out something.
Global,
Yeah,
that or ask them, hey, how long does it take? If it takes 6 months to get a lab back, I mean, that's unreasonable.
yeah.
I'm with you at that point. So,
For the time being, I'll put an eval to do it for us.
For sure.
Next setting.
yeah,
Sounds good. Thank you, Judge.
for sure. Good morning, Mr. Eli. Come on up. How are you? I know you don't want to go into treatment, right? And I acquiesced to you last time. You asked me, please, I can get it done. Please don't let me do it. Don't put me in residential. Don't. And I listened. And what happened? No. Or, yeah, you caught a felony DWI, not. We put you on probation. A month and a half later, you pick up a felony DWI. So all this, acting. So now, if this doesn't show that residential is the right thing, then I don't know what does. You know, the only thing that we're trying to do is prevent death on our roads. That's the only thing, right? And somehow we have to get through these. Every other way that we've tried just doesn't work. This is the only other thing that we have left at our disposal. So if you want, we can just set up a hearing. And if they prove to us that you have violated your probation, then we're going to amend your conditions to put you in residential treatment. We can do this any number of ways. We can have a full-blown hearing, or you can just sign the conditions. But if they prove it to me, that's what's going to happen.
I'm not signing the conditions.
Okay, so set up for a hearing, and then get the probation officer here, and then we'll see. And then they prove to me that you have violated your probation, then I'm going to amend your conditions. I'm not letting you go. Ever. Do you understand? I'm going to keep you until we get this straightened out, one way or the other. Understand? Okay, good. So I'm at your mercy when you want to set it. You want to do a week? We can set it in a week and then just have a hearing. It's just at the mercy of the probation officer, whatever they are best with. Okay?
Morning, sir.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Complainant and defendant are in a former dating relationship. On 6/29, officers were dispatched to a disturbance at a business in Harris County, Texas. Complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed defendant had followed her. Complainant said the defendant was intoxicated and started to insult her. Complainant stated defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck, causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you said?
Yes, Judge. We have not been able to arrest her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned to intake, but in the offense report, it does look like she was 4 months pregnant at the time and the defendant was aware. So this may be refiled as a felony. I'm not sure yet, but it's sort of that right now.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You are not to have any contact with the complaining witness in this case, not to be in possession of weapons, and I'm now entering what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Sir.
If you violate this court order, the state can and will probably file a violation of protective order, and that is the capital murder of misdemeanors. It is one of the worst cases you can pick up, a violation of protective order. Do you understand?
Sir.
You pick up one of those, violate conditions, I can have a hearing to hold you at no bond, zero bond, and I'll do it in a heartbeat to protect my county. Any prior assaults against this person or?
No, Judge, this looks like it's the first one.
Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Parr. If he tells me he can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for arrest. You get no more PR bonds. Do you understand?
Yes, sir.
You will be randomly called upon to go take drug and alcohol tests. If you fail to go, then likewise a warrant for your arrest will be issued. I'll have you go sign a reset with Victoria. You'll sign the order for protection here. You'll get with Felicia for your bond conditions, and after that, you're free to go.
Just,
Oh, is there no bond set?
well, no,
There
there
is.
is. With regards to the bond conditions, I was wondering if we could, amend those or have them reflect the no threatened harassing communication, instead of no contact. They do.
They haven't been able to reach her.
They haven't, but the DA hasn't, but that she has spoken with her back. She had spoken to the back and told her that she didn't want to proceed with the case. She would,
I don't know. I mean, if she's 4 months pregnant,
no,
you
she's
know,
already had the child. They already have a child now. That's the only reason why I say now.
Yeah,
because
this did happen back in June.
They do have a.
If,
well, let's do this. I want to know, I mean, if that VAC was done, that VAC was done in 2024. I don't know anything recent. So until I know what she wants now, then, you know, and if you could, you know, facilitate, perhaps give a phone number, maybe that's something that can happen now. I don't know, but I like to follow the wishes of the complaining witness, and I don't know what her wishes are. If she doesn't want contact with you, then I'm gonna worry. If she does, then we can revisit it at that time. But understand, for this instant, no means no. It doesn't mean maybe. It doesn't mean I got to go get my kid. It doesn't mean someone has to go take the SAT. No means no. Do you understand?
Sir.
Okay. All right. Thanks, guys.
This way.
Good morning, Mr. DePaz.
Good morning.
So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Oh, thank you. Okay.
On March 10th, 2025, at approximately 12:18 p.m., a school resource officer responded to a security officer needing assistance in LaPorte High School. Upon arrival, the defendant was placed in the security resources office after a physical altercation. Defendant stated he was upset with the complainant because the complainant had mistreated his sister in the past. The defendant confronted the complainant and struck the complainant with a closed fist on his face. The defendant was observed on school CCTV walking up to the complainant and punching him with a closed fist, and shortly after, the complainant fell to the ground. The complainant did not show signs of confrontation towards the defendant. The complainant was observed with multiple lacerations on his lower lip and a missing tooth from being struck in the face. The complainant was also observed with a swollen jaw and bleeding from his mouth, and the complainant felt pain. I have spoken to the family of the complainant. He's had to have his jaw wired shut. His jaw was broken on both sides of his face.
Serious bodily injury?
I don't believe that would rise to the level of serious bodily injury because it's not permanent disfigurement, because he will heal eventually, but it will take 6 to 9 weeks.
Mr. DePaz, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're smoking weed, if I find that you're using alcohol, I will put you in jail. You will get your degree with me. Do you understand? You are now not to go back to LaPorte High School. I'm ordering you not to go back. I don't want this person to live in fear, so you're not to go back there. Do you understand?
Yes,
If
sir.
I find that you become a danger to my community, I only have one place for you.
Yes, sir.
You're not to be in possession of weapons as well. You were what, 17?
Yes, sir.
Okay, I will provide you a lawyer today. I'm sending you for a drug test. I want to know what, if anything, is going to be in your system. You're to take a test and you're to come back, and then I'll have you speak to a lawyer.
Yes, sir.
If you don't go take the test, if you don't come back, I will issue a warrant for your arrest.
Yes, sir.
I know it's your problem. You got out of jail because we gave you a free bond. You're not going to get another one if you're a danger to my community.
Yes,
You
sir.
understand?
I will not cause any.
Okay,
And Judge, did you say no contact with the complaining witness?
Correct.
Okay.
but don't worry, don't file anything because I'm going to have him supervised. All right, so just reach out to the MAC form, please, and I'm going to send him for a test right now.
Okay. Well,
Rand. How are you? Right. How are you? Judge looks very festive today.
So this is an FSGI, am I right?
Yes, sir. Hola, yo te voy a interpretar, ¿ok?
Good morning, Ms. Reyes.
Yes, señora Reyes.
Good morning.
Ms. Reyes, you're charged with failure to stop and give information. Essentially, leaving the scene of an accident without exchanging information.
de un accidente sin intercambiar la información que necesitamos hacer.
You are facing up to 180 days in jail
180 días en la cárcel por
and or a $2,000
una
fine.
multa que no sobrepase $2,000.
We are going to do probable cause.
Soldados.
You have the right to remain silent. Anything you say can or will be used against you.
Contra usted.
I insist she stays high.
Y tu abogado insiste que se quede callada.
Just please go slow.
Yes, Your Honor. On March
El
10th,
10 de marzo
2025,
del 2025,
Officers were dispatched to
oficial
Safer
fueron
Street
a
and
una calle Safer
Princess Street in reference to an
Street.
FSGI.
a una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger left
oficiales
the scene
dijeron que
following
un
an
White Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
y iba
Street.
en camino al sur en la calle Shaver.
The complainant stated that she
quejante
was
dijo
traveling when a
que ella
white
estaba
Dodger
manejando
made a
cuando un
unsafe lane
Dodger
change
Cambió de carril, pero sin
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo,
picture of the
Él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó al oficial
showed the license
y
plate
tenía la
and
placa
damage to the vehicle
y
on
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
él
$1,000.
está estimando que costó como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
Vieron la
owner to
placa
be Juan
y
Maneno.
encontraron que el dueño era Juan Menero.
The officer located the vehicle at the apartment complex
Encontraron
that the
el
vehicle was
vehículo
registered
en
to.
los apartamentos a donde estaba registrado.
The officer met with
Y
Juan
el
and his
oficial
wife, who's
habló
the
con Juan y
defendant.
la esposa, que es la acusada.
Juan advised the officers that the
Y Juan
defendant
le
had been
dijo
driving the
que la
vehicle all
acusada
day,
estaba
that
manejando todo el día el
and
vehículo
that the only damage to
que
the vehicle should have been on the
daño
front bumper from a
que
previous
tenía el
incident and
vehículo era
nothing
en la
else.
parte de frente de un accidente previo.
The defendant
Y
advised
el
officers
acusado
that she was
le
driving the
dijo
vehicle and
que
had
ella estaba
recently gotten
manejando
back from a Walmart,
el vehículo y había regresado
which
de
is around
Walmart
700
como
feet from where the
unos
incident
700
occurred.
pies de a donde ocurrió el
She denied hitting
incidente
anybody.
y ella negó pegarle a cualquier persona. Negó que
Your Honor, so based on the
y basado
information,
en la
the
información dice
car was registered to his wife.
So, how do we know who's
And
driving
the
it?
complaint,
y
the
cómo sabe quién
Juan
está
stated that
manejando.
he was the one driving and she admitted to being in that location at the time.
She denied hitting, right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she was the one, within 700 feet of the accident and that she had
Estaba
access to the vehicle, Your Honor.
tenía acceso al vehículo y estaba 700
And this
pies
vehicle was the one that was in the
del lugar.
accident.
Y ese fue el vehículo que estaba en el accidente.
Did you say that the husband said that she was driving it?
She was driving
El
it all day.
esposo dijo que estaba manejando.
statement.
Dice que sí.
You want to add anything? Did you want to say anything?
No, well,
Yeah,
two things, Judge. Number one, there was no evidence that
No hay
she
evidencia.
was, as you mentioned, there was no evidence that she was
Que ella
driving the
estaba
vehicle. And just because she had the vehicle all day does
Solo
not mean she
dice
was
porque
driving
tenía
it.
el vehículo ese día.
For example,
No
when I'm sure my
significa
daughter's
que estaba
home,
manejando.
I'm sure,
Porque cuando
and she's using one of our vehicles, I'm sure that
Mi hija
her lunkhead
estaba usando
boyfriend is probably driving it for the majority of the
vehículo
time.
puede ser que
Additionally,
el
this
novio de
vehicle
mi hija
is
estaba
insured.
manejando. Ahora el vehículo
There's
está-
never been
tiene
any
su- está
report
asegurado.
of anyone, but people had consent to drive it, driving it. That defense is not going to be erased, so this is an insured incident.
It's just,
Es un incidente.
you got A, you got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just,
no hay
I
prueba.
don't think there's enough, All right, I'm gonna find out probable cause in your case, man.
Va a encontrar que hay motivos fundados para mantenerte.
Please be careful when you're driving.
Ten cuidado con
If you're going to drive, do not drive unless you have a valid license
no manejes
and liability insurance in your name.
y seguro.
Do you understand?
¿Entendido?
Okay, all right.
And she does,
Yes.
for the court's edification.
Thanks, Randy.
Always great seeing you, and I apologize on the record for calling in my future son-in-law's a lunkhead, in case that goes anywhere. I forgot it's being videoed. All right, take care.
Ross?
I keep forgetting.
Question: the judge dismissed the FSGI, failure to stop and give information case against Miss Ray due to insufficient evidence. The husband's statement placing her in the vehicle and her proximity to the scene were deemed inadequate under Texas Transportation Code, Section 550.021, duty to stop after accident, and the Fourth Amendment standard from Illinois v. Gates, 1983, for probable cause, did the evidence presented, witness identification, vehicle registration, and admission of being in the area, meet the constitutional threshold for probable cause, or was the dismissal legally sound?
Are you, Ms. Jacobs?
Yes, sir.
Ma'am, you're charged with failure to comply, I guess striking an unattended vehicle. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
On February 27, 2025, an officer responded to an FSGI call in the HEB parking lot in Houston, Harris County, Texas. The complainant reported that while shopping, her vehicle was backed into by an unknown individual who did not stop. When she returned to her vehicle, a note was left with a license plate number, a witness's phone number, and a statement about the incident. The witness confirmed seeing a vehicle back into the complainant's vehicle and drive off. The witness gave a description of the defendant and her vehicle. On March 4th, 2025, an officer met with the loss prevention manager at HEB and was shown surveillance video from the parking lot, which showed the defendant driving over a curb and parking her vehicle. The defendant did shopping in the store and got back in her vehicle. The defendant began to reverse into the complainant's vehicle. The defendant paused briefly before driving off and exiting the parking lot. Surveillance video clearly showed the defendant as well as the defendant's vehicle's license plate. The officer confirmed the license plate was registered to the vehicle and the registered owner was the defendant. The officer compared the driver's license photo with the surveillance images and positively identified the defendant. The officer called the defendant and the defendant acknowledged he rubbed another car with her bumper. The complainant provided photographs of the damage to her car along with an estimate that the total cost of repair would be $3,009.23.
Okay. Ms. Jacobs, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run her license, please? See if she has a valid license.
Yes, Judge.
I'm ordering you not to drive any vehicle unless you have a valid Texas driver license and liability insurance in your name. That's the only condition I'm putting on you at this time. Do not pick up any new cases. If you do, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, man?
Driver's license is valid.
Okay, so we're just going to craft bond conditions for you not to drive without insurance as well. We'll have you sign it, and after that, you'll be free to go. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you if and when you have to come back to court. If he tells me he can't get hold of you because you've gone AWOL, I will issue a warrant for your arrest. All right? We'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thank you, guys.
Right this way.
Good morning, Mr. Macias.
Buenos días, señor.
Sir, you are charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Quiet.
You have the right to have an attorney present.
El derecho de tener un abogado presente.
If you cannot afford one will be appointed to you.
Van a asignar un abogado de oficio.
On March 10th,
El 10 de marzo
2025,
del 25,
at approximately 5:03 p.m.,
5:03 de la
an
tarde,
officer
un
was
oficial
dispatched to
lo
a
llamaron
disturbance,
a una
unknown weapon call
por una
at a
llamada de
residence
que tenga una
in
arma
Harris County,
aquí
Texas.
en una residencia en el condado de Harrison.
The officer made
El
contact
oficial hizo
with the
contacto con
defendant
el acusado, usted,
and complainant
y el quejante
on the sidewalk of
ahí
the
en la
residence.
acera de la residencia.
The officer
El oficial
observed the
observó
call was related
que la llamada
to
era
a previous call
relacionado a otra llamada
on
previa
March 6th,
del 6 de marzo
2025.
del 2025 que estaba
The defendant stated his right
acusado
hand
dijo
was
que la mano
injured
derecha le hicieron
approximately
daño
3 days ago
hace como 3 días
because he fought with the
porque había
complainant
peleado con el
who
quejante
beat up the defendant
que
and that he was
había
sitting
dado
outside
golpes
playing
y
guitar
estaba afuera
on the day of the
tocando
incident.
guitarra el día que ocurrió el
The
incidente.
complainant became
El
upset
quejante
because he
se
did not
enojó
like the noise and that
porque
the
no tenía,
complainant
no le gustó el ruido
complains about music all the time.
y él siempre está quejándose sobre la música siempre.
And that the complainant caught him
Y
at a
el
bad
quejante
time
lo agarró un tiempo que estaba
because he was
tomando
drinking alcohol
tomando
and was
alcohol
angry.
y estaba enojado.
The defendant stated he was tired
El
of the
acusado
complainant
dijo
constantly
que estaba
bothering him,
cansado de que él siempre se está molestando
that the complainant deserved to get beat up,
y le merecía que le
and if
dieran una
officers
paliza
released
y el
him,
oficial
he would
lo
show
dejaron
them what he
ir
could do
y le
by
iba a
assaulting the
enseñar
complainant
qué ibas a
again.
hacer por agredirle otra vez.
The defendant stated he did
El
nothing wrong.
acusado dijo que no hizo nada mal.
The complainant stated
El
that on
quejante
March 6,
dijo que el 6 de
2025,
marzo del
he was
2025
assaulted by
lo
multiple
agredió a
males.
varios hombres.
He was taking out
Él
the
estaba
laundry
sacando
when the
su ropa
suspect started
sucia
calling him
cuando el sospechoso
racial
empezó a llamar
slurs,
un montón de
assaulted
palabras
him,
raciales y le
and dropped him to the
agredió
ground.
y le tiró al piso.
The complainant stated the suspect
El
punched him
quejante
on the
dijo
right
que
side
el
of his face
sospechoso le pegó
with
en
a
la cara
closed
derecha
fist,
de
causing
la
pain.
cara con un puño, causando
He
dolor
sustained
y
an
le
injury
dio
to his right knee and right
una
hand
lesión en la rodilla derecha y la mano derecha.
and left side of
his torso was
Y al
hurt
lado
as he
izquierdo al
believed he was
torso,
hit.
porque parece que él cree que le habían dado una patada.
On March 10th,
El 10 de
2025,
marzo
the complainant
del
stated
2025,
one of the suspects
antes dijo
who attacked
que uno de
him
los sospechosos que le habían
on March 6th,
atacado el 6 de
2025
marzo de 2025
was at the location.
estaba en ese lugar
The complainant pointed at the
y el que
defendant
antes le apuntó
and stated he had to go to the
al
hospital
acusado
due
y
to
le dijo
injuries.
que tenía que haber ido
Did you
al
identify
hospital.
him?
The defendant was
Lo
identified with
Lo
his Mexican
identificó
voter ID card.
con
Yes, the
tarjeta de
complainant
votar
pointed at the
mexicana.
defendant, stating he was the
Él
one
lo
who attacked him
apuntó
on
al
March.
acusado y dijo que él fue quien la atacó.
Mr. Macias, I'm going to find if there's sufficient probable cause to go forward with your
Yeah.
case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness,
Que no tenga ningún contacto,
not to be in possession of weapons,
o sea,
not to go within 200 feet of where he lives or where he works.
él vive o trabaja.
I don't know what your immigration status is, but if you're not in this country with permission
Si no
and you
estás
go to jail and immigration finds you because they sweep it daily, they will put an immigration detainer on you and you will be stuck in custody until this case is over with. And then you get shipped off to immigration, where you'll sit for another 6 to 9 months. I do not want that to
esos
happen
9 meses,
and don't
es que eso
become a danger to my community. I don't care what is going on in your life. I don't care who bothers you. If I find that you pick up another case, you become a danger.
Otro
It's
caso,
not going to go well
el
for you.
peligro a esta comunidad no te va a ir bien.
You understand?
¿Entendido? Sí. Yes.
Do you have a lawyer today?
¿Tienes un abogado hoy?
No lo tengo.
No, sir. No,
You
no
have
hay
the ability to
abogado.
hire a lawyer.
¿Tienes por la capacidad de contratar a un abogado?
De momento estoy fracturado, no.
At this moment, I have a fracture.
You have the ability to hire a lawyer.
¿Tienes el dinero para contratar a un abogado?
De momento no.
At this moment, no.
I'll have you fill out an application. I'll see whether you qualify. I need to know everything about you. I need to know how much money you have in the bank,
Todo.
what you have money coming in, what kind of property you have, and then I'll take a look. We will create bond conditions for you.
Pues va a
Did you
decir-
say that alcohol was a factor in this?
Yes, Judge. The defendant
Preguntó si
stated
había
he
alcohol
was
en este
angry
caso.
because he
Dice que
was
sí,
drinking that
porque
day.
estabas enojado ese día porque estabas
I'm
tomando
also
ese día.
ordering not to consume
También
alcohol.
te voy a
Legal
ordenar
drugs.
que no tomes alcohol.
Test you. Mr. Macias, if I find that you're consuming alcohol, likewise, I will put you in jail.
Encuentro que estás tomando
Do you
alcohol
understand?
en la cárcel, ¿entendió? Sí. Yes.
I will, Deputy Miranda's going to give an application. I'll have you sign a receipt with Victoria. You'll get, we'll police you for your bond conditions, and then we'll have you take a seat in
Y
your
vamos a ver
box.
si te vamos a dar un abogado de quieres de fianza. Pase allá.
Don't worry about filing conditions because,
I have a plea, Judge.
you ready?
Yes, Judge. Felipe Alvarado.
Mr. Alvarado, come up. Hi there. Hey. Hey, the lady from yesterday, is she up here?
Sí, señor, no, señor.
Mr. Alvarado, you were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you have done. You need to understand that this charge will go on your record after today, and it will be there for the rest of your life. From now on, you will be facing a minimum of 30 days in jail for any new cases that you pick up. So no more slaps on the wrist, as it were. You get pulled over from now on, and you have the slightest smell of alcohol in your breath, an officer sees this DWI, it's probably not going to go well for you. Do you understand?
Yes, yes, sir.
Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
Lo que tienes que hacer es lo que quieres hacer tú. Tienes que ser culpable. Soy culpable. I am guilty.
I'm going to find you guilty. I will follow the agreement. The other thing is that there is a $3,000 surcharge that tacks onto your license and onto you when you pick up a case like this. I will waive it today. But if you continue to endanger our community, the next time a second offense, it's a $6,000 surcharge. And if you don't pay it, every $100 you owe you sit 1 day in jail. So get a clue. From now on, if you want to have 32 beers, 52 shots, take an Uber. It's not hard. I am going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir.
No, we'll pay for this, please.
Yeah.
Motion on outright ground, it's an arraignment and a motion to sub.
All right, come on. You ready? Bring your client.
Page 6.
Motion to sub, I think we filed it here yesterday. We did been filed a while ago, wasn't it? We just reached.
I think it makes them.
It's already attached. Right?
Yeah. Those were habits. Okay, just making sure my notes just said.
Good morning.
You're Alvin Brown.
I am.
You're facing an assault causing bodily injury. You're facing up to a year in jail.
I don't believe so, Your Honor. I believe this is an interference with the public.
Right, I'm looking.
Yeah, and that's not.
Yes, you're right. Interference with the duties of a public servant. 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 11th, 2025, at approximately 1:21 p.m., the officer observed a vehicle speeding at 48 miles per hour in a 35 miles per hour zone, and a temporary tag that came back as expired as of March 3rd, 2025. A traffic stop was initiated. The defendant stopped in the middle of the road, and the officer signaled for the defendant to pull over to the nearest parking lot. The defendant opened the driver's side door and attempted to step out. She became hostile and then was yelling and cursing. The defendant was giving commands to walk in front of the officer's patrol vehicle. Since the defendant was not complying with commands to get back inside the vehicle, the defendant then walked partially to the back of their car, and the officer detained the defendant and began actively resisting. The defendant was given multiple commands to place their hands behind their back, and the defendant continued to pull away and tense on the officer's attempt to walk them back to the car. The defendant then locked onto the door to prevent the officer from placing handcuffs. The defendant was taken to the ground where they continued to resist. The defendant was tased after giving repetitive commands and not complying. The defendant was then successfully placed into handcuffs, and it was later learned that the defendant had an unloaded firearm in their vehicle and was identified by their Texas driver's license.
Okay, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run the license, please? Make sure it's eligible.
There is no driver's license on file, Your Honor.
Yeah, and I have it eligible. My driver's license is valid.
Unless you have a valid Texas driver license and liability insurance in your name, you're not allowed to drive. It's a condition of your bond. That's the only condition I'm going to put on you. Just when you get into a pissing match with someone with power of arrest, who's going to win? Don't say anything as a rhetorical question, but really, people have been shot for far less. You got to be careful in this life. You only get one. You know what I mean? Really?
Yes, sir.
All right. I'm not, like I said, the only condition is just drive with a license and insurance. You've got lawyers, so they'll take care of you because you have a lawyer. I will waive your appearance. You don't have to waste your time coming to court, but just stay in touch with them. They'll tell you if and when you have to come back to court. If they tell me if they tell me they can't get a hold of you, if you take off, you pick up a new case, I am going to revoke your bond, put you in jail. No more PR bonds. Just be nice. It's not hard. All right.
Yes, sir.
I'll have you sign a receipt, Victoria. We'll have you take a seat while I get your bond conditions. We'll have you sign it, and then you're free to go. Mr. Racines, you're charged with driving while intoxicated. You have worked out an agreement where they're offering you 180 days in jail to be probated for 12 months. As part of this agreement, you will do a DWI education class, a victim okay, no victim impact family, I guess, no? Okay. You will also do a TRAS, which is an evaluation to see what other conditions you may need. They may assess more conditions, they may assess no other conditions. If they assess further conditions, you must fulfill them. No drugs, no alcohol, guardian interlock, and 20 hours of community service. Substance abuse treatment as recommended by the TRAS. These are the conditions for you to successfully complete this probation. If you complete it, regardless, you need to understand that this DWI is going on your record. It will be there for the rest of your life. You can never take it off. From now on, you will be facing a minimum of 30 days in jail for any new cases you pick up. Because this is going on the record, you get caught in a car driving, cop pulls you over, you have the faintest smell of alcohol, they see this DWI, it's probably not going to go well for you. Do you understand?
Yes, sir.
So even if you've had a sip of alcohol, I wouldn't get into a car because you're taking a huge risk. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, it goes on your record. It's going to be there forever. Like I said, you give up this right to appeal. Now, on this probation, no drugs, no alcohol for an entire year. If we find that you're using, if you don't do your community service on time, if you fail to do your class on time, I will issue a warrant for your arrest. I'm going to put you in jail and bring you back out, and we're going to have a hearing to determine whether you violated this probation. You're looking at 180 days if you do. You understand?
Yes, sir.
Do you still want to do this?
Yes, sir.
Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to send you to the agreement. Before we leave, can you run his license to see whether he...
Yes, I can do that right now. It is currently suspended for ALR.
Right. That's what I figured. Your license currently is suspended because of the administrative license revocation hearing. You are not allowed to drive. So if you drove here, you may not drive home. Do you understand? So you're going to have to get someone else to drive the car home for you. Because you don't have a license now, we will require you to obtain a portable device that you're going to take with you to prove to us that you're not consuming alcohol while you're on this probation. So let's make it a condition that he get his license back. Now I'm adding on another condition that you need to get your license back. It's not hard. I think all you have to do is just pay a reinstatement fee. That's it. So it's not difficult, but you need to do that. And if you don't, if you start driving on this probation, you don't have a license, you're looking at 180 days. So don't just drive. You need to ensure that your license is valid with DPS. Once you pay that reinstatement fee, it takes 2 to 3 weeks just to get back in. So don't just start driving once you pay it because it's not reflected in the system. Do you understand?
Yes, sir.
Okay. All right. Good luck, bud.
Thank you, Your Honor.
Thank you, City. Good morning, Mr. Callahan.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 6 days in jail, credit for the 2 days that you've done. This is a plea. It's a plea of guilty. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. It's even there after you die. It's important because if you get pulled over, officers see this, they come up to your car, they smell alcohol, it's probably not going to go well for you. And what we're doing today, time served, you're facing a minimum of 30 days in jail after today. Do you understand? Is it true first?
Double check. I believe it is your honor, but.
The other thing that you need to understand is that DWI is extremely big business in Texas, meaning that there's a $3,000 surcharge that tacks onto you when you have a case like this. And if you don't pay it, you sit 1 day in jail for every $100 you owe. We all make mistakes, and I'm going to waive that for you today. But if you continue to make the same mistakes where you endanger other people's lives, it just gets so much worse. A second DWI, $6,000 surcharge. Do you understand? All right. We all make mistakes. Just don't make another one. You know what I mean? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, there's no turning back. It's going to go on your record. Is this what you want to do? All right. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I also have to suspend your license. I will suspend it for the minimum, which is 90 days. Do not drive until you get a license. Good luck to you, sir. All right. I'll just do the third. Good morning, Mr. Moore. Sir, you're charged with driving while intoxicated. I'm sorry. You're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail. Do you understand?
Yes, sir.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, there's no turning back. You understand?
Yes, sir.
Is this what you want to do? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement. Good luck to you, sir. Thank you.
Thank you.
And we'll roll your court costs. Mr. Butler.
Judge, how much time should you give for Steven?
3 weeks, whatever she wants.
I mean, with the record, does it matter? Man?
Yeah.
Okay. Basically, Judge, our argument in the writ is that even if there's a detainer, he shouldn't be held in custody over 48 hours. We cite some case law.
He's on bond. So I don't know what I can do to release him. And so when I was going to call the court manager's office, figure out why is he still being held? Because he's on bond. Why has immigration why have they not picked him up? And because I'm confused, I'm as much as confused as you.
Who's he talking about?
What's the name again?
Martinez?
Martinez.
Because a bench warrant was requested. So Billy called about this one because she was tuning in. And she says that he's here because we bench warrant him here. And that if y'all want him to go back, then we have to do a bench warrant return.
But my question is, and because that's
We
why,
bench warrant people here because people ask him to be bench warrant. We don't do it on our own, right? So someone has to ask us. So someone must have asked for the bench warrant.
I believe his prior attorney, because we're doing this pro bono because we were helping him with the immigration case,
Okay.
filed the bench warrant. But as
So
far
we
as,
can do a return.
yes, Judge, but as far as I know, like the court stated, he paid the bond, so there's no reason for him to be detained. I have no problem if he's returned. That's fine too. But it really, it's something that it seems to me that lately it's happening more than it should, and that's why we filed that writ.
Lawyers ask us to do with when these things happen. So if someone wants a bond revoked so that they don't go to immigration, we do it. If someone wants to have a bond so they can go to immigration, we do it. I always do what defense lawyers ask me regardless. So,
And I'm unaware of that.
so
Judge.
someone asked them to be brought here. My feeling is so that they could take care of the case before he gets deported. That's what we normally do. So,
I believe that was done before we were helping him with his immigration
so-
case.
So what we'll do now is we can send him back when he gets back to immigration.
Oh,
That way, guys, you can make the
Because he already
bond.
has a bond, yeah.
And I won't revoke it here. The only thing I'm going to ask you to do is when you do make the bond over there, bring him here so we can do conditions.
Yes, sir.
And then we'll just keep it open until you guys are ready. So just let her know to do the return and then I don't know how long it'll take to get it like back, but
That's why we filed the writ, Judge.
hey Vic, when we do the return to go back there, how long does it take to get him back?
They're here pretty often, so I mean, I'm sure in a week, they'll be back.
Yeah, and he should be detained for more than 48 hours because usually if not, that's why they're released.
Yes, but unless there's other circumstances, and when there's an immigration detainer, it's not us that's technically holding him, it's the immigration.
That's why we are in the motion, Judge. It's just, if the court could take a look whenever it has a chance. It would be
Sure.
good.
Yeah, but we'll do the return now so that we can just get him back in.
Whatever is fast, that's fine because
This is the fastest way,
they will.
Do you want me,
right?
Yes, to send them back, yes.
we can do that. Do you want me to put that application for habeas corpus in the queue, the one that he's talking about?
But I don't know, like if I grant it, I mean, it's just.
Can I ask you just a favor, Judge? If the court just, I mean, I think whatever is faster, I'm fine with that because we already got a bond for him there. But if
I
the court
think
could
what
take,
she's saying is probably the fastest.
but if the court could also, whenever have a chance,
Take a
take a
look
look
at
at my motion, okay?
Okay.
And maybe it's
Just
just,
let her know and then we'll get it done for you now
thank
today.
you, sir. Thank you.
Good morning, Ms. Jason.
Good morning.
Ma'am, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 21 days in jail with credit for the 7 days that you've done.
Sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you understand?
Yes,
Is this what you want to do?
yes,
How do you plead to the offense of criminal trespass, ma'am?
I'm guilty.
I'll find you guilty, sentence you to the agreement. Good luck to you, ma'am.
I'll go back there.
Thanks.
All right. You're good. You got it. Thank you.
Thanks. Good morning, Mr. Sager. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Essentially, you and the state have not been able to work out an agreement, so you're coming to me for punishment for purposes of this case that you want to end today. Is that right? You need to understand that you give up a lot of rights by entering into this agreement. You're facing 180 days in jail. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So whatever happens today happens, and that's it. There's no turning around and trying to change your mind. Do you understand?
Yes, sir.
Now, I'm a firm believer that everybody deserves a chance. Really. But the problem is we have people that we give them chances and they take the chance, but then it continues to happen over and over and over. And that's what we are trying to prevent from happening with you, Mr. Sager. You know, we all make mistakes, but the problem is that when you make a mistake where you're in danger of someone's life, you have to take notice. And when you don't, and when it continues to happen, if it continues to happen, the sentences get longer. The costs become bigger, especially with the DWI. Now you're facing, like I said, the 6 months, your lawyer's asking me to set you for a deferred, which is a type of probation that if you complete, you do not end up with a conviction on your record. I will do this for you today. I will set you on a 1-year deferred. I'm going to sentence you to 180 days in jail, and I will not find you guilty, and I will put you on this deferred for a year. However, you will be required to satisfy conditions. If you do, fantastic, you will not end up with a conviction on your record. But you need to understand something. For all intents and purposes, if you're pulled over, an officer's going to see this. They're not going to give a rat's behind whether it's a deferred, whether it's a conviction, whether it's a dismissal. If they see that you have a prior DWI and they smell alcohol on you, it's probably not going to go well for you. Do you understand?
Yes, sir.
So what I'm trying to say is that even if you have half a beer, a sip of something, don't get into a car because it's a huge risk. Do you understand?
Yes, sir.
So it is a 180-day, 1-year deferred. You will maintain a guardian interlock while you're on this deferred. You will do a DWI education class, a victim impact panel. Do you have children? We will do a parenting class in lieu of community service.
Sure.
No drugs, alcohol. You will do what's called a TRAS to see if you need other conditions. If they assess other conditions, you must fulfill those conditions. No breath test refusal, meaning that if you're pulled over in a car, an officer asks you to submit a breath test, you must do it while you're on this probation. If you don't, you're in violation. If you violate this probation, I will issue a warrant for your arrest. We will have a hearing to see if you violated this. And as you see all the people that came out, you'll be dressed in orange. We're going to bring you back out. We're going to have a hearing to see if you violated. If you do, or if you did, you're looking at 180 days. Do you understand?
Yes, sir.
Do you mind running his license to see if it's eligible, please?
Yes, Your Honor.
I didn't forget anything, did I? That's about it. So the only other thing I'd like to know now is whether your license is eligible or not. Because if it's not eligible, I'm going to order you not to drive and we'll give you a portable device. You're not allowed to drive unless you have a valid license and liability insurance in your name. You must maintain car insurance while you're on this probation. You must give them proof so that we know that you're driving legally.
It's eligible.
Wonderful. Okay. I'm not going to suspend your license now, so you can continue to drive, but you must get an interlock within 7 days. Do you understand?
7 days?
Correct. Yeah. Do you have any questions?
No, sir, not this time.
The only other thing that I'm going to impart to you now is that DWI is huge business in Texas. There is a $3,000 surcharge. Is this a 0.15 or above? It is.
Yes, Your Honor.
All right. Is it true or untrue that you had a 0.15 or above? Oh, I guess you didn't, it's not pled as such, right? Okay. So the reason I'm trying to tell you is that there's a $3,000 surcharge that tags onto you when you pick up one of these types of cases. I'm going to waive it for you now, but on a second DWI, it's a $6,000 surcharge. And if you don't pay it, every $100 you owe, you sit 1 day in jail. And I routinely put it on seconds. So beware, it's going to cost you a pretty penny. You pick up another one, not to mention a minimum of 30 days. Well, there's no minimum because deferred. Do you understand?
Yes, sir.
All right. Good luck to you, sir. Thanks. All right. Good job. Good job. I'm proud of you. Hey.
I'm very happy. So he's been clean. I mean, it sounds like he hasn't been using for a while. So, the state, I think once one more reset, discovery is complete. He has the pending felony. That's reset till like May 21st.
That's a little far.
I understand.
And I know that one upstairs will probably swallow this one regardless. So I guess let's give 30 days, see whatever. Hopefully you're still here. But if you can put a note in the system,
Yeah, I don't know if they're just, because it's not the same transaction, but there are kind of the same, it's the same complaining witnesses, and the felony predates this.
This is the neighbor stuff, right?
Yes. Right. So the felony predates this case, but it was filed afterwards, and it's the same complaining witnesses, but.
That's what I mean. They're somewhat connected.
Yeah, I mean.
They're not same transaction.
It's complete upstairs too?
I think so.
Yes, Judge.
For the record, I do hope it's still here.
Okay, so let's do 30 days and then we'll see. Come back. Hopefully everything will.
Do we have a required setting or? Parents wait.
What do you think? What do you want?
He's been in good contact with me,
Come up, Miss Alexander. I'll waive it.
Okay.
But I'm gonna test him at least one more time. Let him know. This is not to. You're doing good, man. You're doing good. You're in the home stretch. Okay. Just keep it up. I'm gonna test you at least one more time. Don't use. Just stay, keep your nose out of trouble and all's gonna go well. You're in the home stretch. Okay? All right.
Thank you.
I'll wait it for the next one.
Okay. And then if it's.
But he's gonna get called at some point.
I understand.
Okay. All right, guys. Good luck, Michelle Alexander. And the weapon's gonna get forfeited, right? Okay. Mr. Melendez, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, this is going on your record. You need to understand that from now on, you're facing a minimum of 90 days in jail. Anything. Do you understand?
Yes, sir.
No more slaps on the wrist. It's a minimum 90 days. So if you're running with knuckleheads, get ready. When you hang with dogs, you get fleas. As part of the agreement, the weapon is going to be forfeited. You will not get it back. Do you understand? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty and I'm going to follow the agreement. Good luck, Mr. Mullins.
Okay, Judge.
Thanks.
Sure.
What we saw today is a typical Texas misdemeanor docket. DWIS, assaults, probation violations. The judge consistently balanced second chances with public safety, waiving surcharges for first-timers while threatening maximum consequences for repeat offenders. The message was clear. 1 strike, you get help. 2 strikes, you get jail.